All right, on behalf of the committee, resolution number 2021-09-040R, resolution approving a collective bargaining agreement with the Fraternal Order of Police Lodge number 70 for a term of July 1st, 2020 through June 30th, 2023. The committee sent this with no recommendation.
Is there a second?
Well, I guess I would have to make a motion, not on behalf of the committee, but I will make a motion for approval.
Is there a second to get this up for discussion?
A second.
Okay. Attorney Ben Garrett is here. I believe Michelle Brooks is as well. There she is. And then we have City Attorney Dave Wessner. Ben and Michelle, did you want to make some comments first, particularly to help provide context for this agreement? Some folks may be watching tonight who weren't here last week, and it's very important, I think, for the public to understand the context that the council is voting in. Any other things you want to address?
Very good, Mayor. Thank you so much, and thank you, Council, for your time once again tonight. The members of the public, there's been a really good spirited discussion about this contract, which I very much welcome and embrace, and I know the Council does as well. And I know a lot of careful thought has gone into this, which I very much appreciate. One of the members in public comment tonight mentioned the fact that the law is not neutral. And when it comes to collective bargaining with police units in the state of Illinois, that is unfortunately very much the case. The law is not neutral. We are bargaining against a stacked deck, and the deck is stacked against us in the provisions of the Illinois Public Labor Relations Act that do not allow management the discretion to make unilateral implementation of management-oriented changes when we reach a bargaining impasse. Rather, the law that is imposed upon the city and its elected officials is that if we cannot reach a voluntary contract settlement with the police officers, that contract dispute has to be submitted to what is called binding interest arbitration, in which a third-party arbitrator will come into the city of Urbana, most likely not a resident of the city, maybe not even a resident of the state, and dictate to the city what the terms of your collective bargaining agreement will say. And that is a very frustrating reality. It's a reality that I deal with as a part of my daily job as a management side labor attorney. But we do not, unfortunately, have the pleasure of writing Illinois state statute. It's just our job to follow that state statute and to bargain within the reality that has been created with us in the framework that has been created for us by the Illinois state legislature. By way of example, I'll talk about discipline cases involving police officers. It used to be that discipline cases involving police officers would go to the Board of Fire and Police Commissioners, or in the city of Urbana, a Civil Service Commission. Section 8, though, of the Illinois Labor Relations Act specifically says that all disputes arising under a collective bargaining agreement have to be submitted to binding grievance arbitrator, which is where a third-party arbitrator comes in and says whether discipline issued against a police officer will be sustained or not. I hate it. I think it takes away from the judgment and discretion of management. It takes away from the judgment and discretion of police chiefs who know what is and is not acceptable conduct in police departments. And it substitutes the judgment of management for somebody who will walk away from a community and not have to deal with the consequences of their decision. Unfortunately, we can't change that in Urbana. It's built into the Illinois Labor Relations Act. My law firm, as well as others, have fought against Section 8 of the Labor Act. We have fought against it in interest arbitration cases. We have fought against it at the Labor Board. We have fought against it with the General Counsel of the Labor Board. But the act is what it is. So that is the bargaining reality that we're dealing with. Part of that bargaining reality is that interest arbitration is viewed as, quote unquote, a very conservative process. Arbitrators loathe to make changes to the status quo. And they urge that any changes to the status quo have to be bargained at the table. Both sides of the table know that. Both sides know that it is very, very, very difficult to achieve change, a significant change in interest arbitration. And because of that, the parties can be recalcitrant in changes that they are opposed to. So when we approach contract negotiations, it's knowing that is the case. That is the reality of the law in Illinois. And I would be remiss if I came to the city of Urbana promising the sun and moon, the moon and the stars, and saying that we were going to be able to rewrite some of these contract provisions ourselves, knowing that reality of interest arbitration. What would happen is you spend a lot of money and time on an interest arbitration hearing simply to be told no. So we strive at every turn to try to reach a voluntary contract settlement that betters the interests and the needs of the community while being mindful of what that alternative to a voluntary contract settlement looks like. So that's the bargaining reality. A couple of other points that I want to address from the open discussion tonight. One is a provision in the CPRB appendix to the collective bargaining agreement that references that members who sit on the CPRB cannot have felony convictions. And I want to emphasize that those are convictions, not simply arrests. If there was a suggestion that that provision might be illegal under the city ordinance, I want to let the council know and assure you that it's not illegal for two reasons. First of all, the Illinois Labor Relations Act, Section 15 of the Illinois Labor Relations Act specifies that the provisions of a collective bargaining agreement trump and supersede over any contrary provisions of an Illinois city ordinance or city code. So that's the first reason. But second of all, more substantively, if you look at Section 12-62, F as in Frank, and then I believe it's number 2 if I'm reading my handwriting correctly, your city code has something called a BFOQ, a bona fide occupational qualification exception to that criminal conviction criteria. And the reason that's there, just to give you an extreme example, if you're a bank robber, you don't get to work for a bank because that is giving you the method, the means, the opportunity to commit repeat offenses. So there are BFOQs in other places in the city. One of the BFOQs, bona fide occupational qualifications, that has existed in the city of Urbana for a while and continues in this contract, is that in order to police the police, you cannot have a felony conviction. So I am comfortable that that is a lawful provision. Moreover, I want to emphasize just again, the conservative nature of collective bargaining. We did make changes in the CPRB section of the collective bargaining agreement. We got rid of the affidavit requirement. We got rid of the threat of conviction if a person came forward with a knowingly false complaint, thereby making it easier for people to come forward with complaints without having to fear repercussions for that. I can tell you that during the bargaining process and in mediation, we pushed the changes to the CPRB as far as we could to get a voluntary contract settlement. There were points in time during negotiations where we did ask for more reform and we were told no. So again, knowing that reality of interest arbitration, where we could go to interest arbitration, and if the union's proposal in interest arbitration was status quo, no changes whatsoever, we might not even be able to get the changes that we did make with the voluntary contract settlement. So the old adage of a bird in the hand versus two in the bush, we took the bird in the hand knowing what that reality of interest arbitration is like on the other side. There's also been some discussion both this week and last week about closed session, and I know a couple of council members have addressed that. I just want to give an example of why it's important to me as your attorney or as your lead negotiator to be able to talk with city council in executive session. And I'll just use an extreme example. When we're bargaining, we don't come to the table with our best offer first. So if the city council or if the discussion with the mayor and the city staff says, you've got authority to do, and I'm just going to pick a random number that's not reality. If you have authority to add 3% per year to the contract, well, in negotiations, if I come to the table and say our opening offer is 1% per year, and the union knows, because we've talked in open session that the real number is 3%, they're not going to take us seriously. So being able to identify bargaining priorities, being able to identify bargaining vulnerabilities, being able to identify where we do and don't have leverage is something that simply we need to be able to do in executive session so that we can come to the bargaining table and negotiate and work to the middle and reach a settlement that is favorable to the city's interests. So as I discussed last week, I do think that this is a favorable contract to the city. The wages are favorable, particularly in this economic environment. Again, a reminder, the wage increases are 1.5% effective July 1st of 2020, 2% of July 1st of 2021, and 2.5% of July 1st of 2022. Compared to the trends in the economy, that's a very favorable settlement. And we have made incremental change in ways that favor the city without having to give up a lot to get it. So in that bargaining reality, in that environment that's created for us by the Illinois State Legislature, this is an agreement that I recommend that the City Council ratify tonight.
Michelle, did you want to add anything?
No, thank you.
Okay. Any questions for Ben? Grace?
Thank you. I was wondering if we could have some information about the timeline here for the first negotiation happening in September of 2020 and discussions starting in March, and talking to the council once in May and then once when the contract was finished. So I'm just wondering if we could have some insight about if that is when they started and why there wasn't any more involvement from council or the public, and why it took so long if negotiations had started at that point.
I'll go ahead and jump in, and if Michelle or anybody has any additional comments. So I'm looking at my bargaining binder right now, and the very first meeting that we had with the union was, I believe, on October 9th of 2020. The contract did expire in June of 2020, but my notes indicate our first meeting with the union was in October. That's not uncommon. It's more common than I'd like it to be in the public sector, but it does happen, and particularly where we're bargaining in an environment of COVID. We did meet with the union several times based on direction from the mayor and city administrator. And then we did brief the council, and I believe you said Councilwoman Grace Wilkin, sorry. We briefed the council back in May, shortly after the new council was elected. And that was just prior to us going to mediation with the union. We went to mediation with the union on June 24th of this year. And we had one and only one mediation session. We were able to get the contract resolved in mediation with some back and forth after by email through the mediator after mediation, but it was basically just the one mediation session after we met with council and executive session back in May. And I'll amplify too, and I apologize, I see Michelle's got her hand up there. I work with different councils in different jurisdictions all across the state, and different councils in different jurisdictions absolutely have different comfort levels and different processes and preferences when it comes to the collective bargaining process. And certainly as part of this contract negotiation, this council's made clear its desires for future negotiations. And I'm sure that the city's bargaining team will take that feedback into future negotiations. I wanted to pause. I know Michelle wanted to comment on that too, I believe.
I apologize, and I invite the mayor, Ben, Elizabeth, or council persons, Wu or Hersey, to correct me if I'm wrong, but I thought we had met with the prior council back before we ever even sat down for a first time with FOP, or very close to a first time. So I think that was part of the issue, is we did brief the council, and then there was a very long period of time and delay with scheduling things due in part to the pandemic. So I know it seems like this has been going on for a very long time. There was a long period when no meetings were had, but there was an initial briefing. It was just with a largely different set of council members.
That's the other issue about this particular session, is that it started under, which is what happens when you have an election, is it started under one city council and ended up under another. And if I recall right, most of the substantial issues were worked out before this new council was even seated. Is that correct?
That is correct. I mean, when we went to mediation, we did have some key issues in terms of wages and economic items like that. But yes, we had narrowed the field of issues quite significantly prior to the new council being sworn in.
And the other thing that people should remember, it did, we are over a year into the new contract period. So there are basically 2 years, less than 2 years left in this particular contract period, and which is not unusual. I've based on my experience on the council, there have been a number of times when we finished up negotiations a year into the contract and then had retroactive pay. So this timing is not unusual. COVID made it worse, like it made everything worse. But this contract spans 2 city councils.
The one other thing I would note too is kind of in the importance of that initial session is when we meet and we kind of find out from council what their priorities are and some of our authority. And I won't go into any specifics of it, but that was kind of where the team got a lot of its initial guidance. So we were given some direction, we were given some guidance, and we went forth based on our understanding of that. But again, there were, several different council members at that time.
And so then going forward, when it's time to begin to prepare for the next round of bargaining, then this council will meet and will have input and establish priorities for that session too. Grace?
Thanks. I also had questions about, the retroactively enacting this contract, particularly with some of the CPRB stuff, like removing that complaints need to be acknowledged with the person involved in the incidents, and removing the language about prosecuting false complaints. I'm wondering how that applies retroactively, if there were situations like this already in the past year, and then what the plan is on how to enact this retroactively.
So to that question, I would say the contract is effective July 1st of 2020. If that was an issue, and I'm not in a position to speak to that, I would not know one way or the other myself. But yes, this contract is effective July 1st of 2020. So that would apply retroactively as well in terms of not submitting anything for criminal conviction based on false complaints.
Does anyone on the city end happen to know if that is the case? If there are, unsigned complaints, or there was any prosecution of a false complaint in that time?
I know we have never prosecuted based upon an allegation of a false complaint regarding a CPRB matter. As to the other, I would have to defer.
Carol, did you want to weigh in on this?
Yes, we have had, there were a number of complaints that were filed, and many of them have been appealed at this point based on the lack of a notary. And we had some complaints as well that were filed by people who were not firsthand witnesses. I don't know the timing on those, so we'll have to go back and review those. And I guess we'll have to figure out if the chief will issue new findings on complaints that were, that were made where actually the chief didn't, now that I'm thinking about it, the chief didn't even get those because they weren't forwarded from the HR, what was at the time the HRO. So we may need to do some work on investigating some of the things that weren't investigated because they didn't advance from the Human Relations Office to the police department. So we'll have to go back and see what we're dealing with there.
But that is the plan, to go back and see if there are any of these that would apply and need to be validated and kind of reopened.
if you pass this, if you ratify this contract, then that will be the state of play for us, and we will do that.
Thank you.
I should just caveat too, I apologize. In my tenure here, we've never pursued any kind of legal recourse against anyone for a false complaint. I can't speak to prior to that, but I do know my tenure here would cover that period of retroactivity.
Any other questions? Grace?
Thank you. Comment, and then I do have a question here too. Just wanted to say that, we already reiterated a lot last week that it was a very frustrating process, and I don't appreciate not hearing anything since the initial conversation, especially if, a lot of the things were even figured out before then. There are a lot of suggestions that myself and I think other council members and members of the public would have suggested, given the opportunity, from big picture stuff to even straightforward stuff like gender neutral language that we decided on as a city that could have been a very straightforward thing to add, given the opportunity for input. So I do think that, we need to do things very differently the next time to have input from council and the public and have more involvement in that process, because there may have been things that wouldn't have been substantial in the negotiating table, possibly for the other side, that we could have added somewhat easily, as well as big picture ideas. So my question is, for this one, I was wondering about voting present. If I could just have clarification for the clerk, if there is any home rule thing that supersedes state procedures for voting present as a no vote.
If you vote present, then that will show in the record as a vote for present. But when it's counted, if it is counted at all, it'd be counted with the winning side.
Great, thank you. So yeah, I do plan to vote that because I think this is not a good position to be in. I don't really agree with passing this contract, and I don't agree with stopping it and taking something potentially in worse interest for the city. And I don't appreciate that we're in this situation to begin with. Thank you.
Sharice?
I guess what I'd like to know, since we did have the, if somebody files a false claim with CPRB and we're not going to, they won't meet consequences of any kind of legal ramifications. Will that person ever be named as filing a false report or anything to that nature?
I'm not
Do
sure
you
which.
mean in like, do you
Go
mean
ahead.
as in a criminal case? Because filing a false report would generally mean a police report as opposed to a CPRB complaint. So there would
A CPRB complaint, it's regarding the CPRB complaint.
So
is
I'll
there-
invite,
Are there any consequences for filing a false CPRB complaint?
the way we have this written now, there would not be anything other than perhaps if somebody who had the complaints or allegations made against them wanted to perhaps try to pursue some form of civil action. Ben, what are your thoughts?
Yeah, my thought is exactly the same, is that from a criminal perspective, from a city perspective, there's nothing that the city could pursue against somebody who submitted a false complaint. And that's essentially the balance that is struck here, right? Is you'd rather get the complaint and find out that it was not founded than to discourage those complaints from coming in the first place. We cannot give up employees' rights to pursue civil remedies if they think that they've been defamed or libeled or something of that nature. So a person would still potentially have that kind of a claim that they could bring forward themselves in their individual capacity, and there's nothing that we can do about that. No different than a member of the public could sue one of your employees on similar types of grounds if they felt that they were defamed or libeled.
I was just wondering because I know that a lot of people's time that are on the CPRB as well as staff time is put in to investigate complaints in general. So it's just, I was just thinking it's something that we already have our issues with trying to get CPRB up and running well, and to have false complaints can kind of gum up those works as far as keeping the city from actually, or the CPRB from actually looking into complaints that are real. So.
Yeah, I mean, I think that's a very legitimate concern, and one that's just a delicate balancing act, and we're going to have to see how things go over the next couple of years here. You know, there's a very controversial law in another state, and I'm not going to mention what it is to avoid politicizing this discussion with something even more controversial. And that law set up a complaint process, and people who were upset with that law responded by flooding that complaint process with a bunch of nonsense. And that when you've got to sort through all of that noise, it makes it harder to get to the real complaints. So certainly, you know, we hope that the public will use the CPRB process appropriately. I would like to think that they will. And if not, then we'll have to look at making some tweaks to it in the future. And by the way, I apologize to Alderwoman Wu. This is simply removing a contractual impediment to the way the CPRB receives complaints. If the council does find that we've shifted the pendulum far too far to the other side, you could always address that with your own ordinances as well. It's simply, your ordinances can't conflict with the collective bargaining agreement, but they could enhance it, so to speak.
Okay, thank you.
Mary Alice.
So I just, I want to dig in a little bit based on kind of the video explanation in terms of how bargaining in the state of Illinois happens and interest arbitration. If something does go to interest arbitration, then there's two separate kind of buckets, so to speak. There's the economic bucket, in which case the arbitrator gets to choose plan A or plan B, right? He doesn't get to pick and choose between the different plans. And each side presents whatever economic argument they want to present, and then they just select one. The second one are the non-economic ones. And so this is when we're going into the retention of records, the CPRB, all of those items. And based on what you said tonight, you said that typically they stick with the status quo. So typically whatever's in our previous contract most likely would be the direction that that person would take. So my question that I pose to City Council is this. I feel like that we're not going to get everything that we want. This is a negotiation between two different entities, and I'm sure that the union would have liked to see other things in the contract. And we didn't get everything that we wanted. We got some things that we wanted. I think that the records retention, the amount of time that you can use disciplinary records for progressive discipline, I think is a really big step forward. I think that removing some of the impediments in the CPRB is a big step forward for us. So the way I see it tonight is there's two questions here. A, does City Council feel that the economic portion that is agreed upon in the voluntary settlement, if that is appropriate for the city? And if it's not, then we have to accept the risk that the union or us would win. So that's one side. The second side is in terms of the non-economic items. Are we happy enough that we want these changes that we have negotiated, or do we want to revert back to what has already been negotiated the year before? So to me, that drives how I make my decision in terms of how to vote for this tonight. I'm happy at least that we have started to build towards more accountability, more transparency. Is it everything that we need? No, I think we can do more, but I do think this is a step in the right direction. And so for that reason, I'm going to be voting for this.
Any other comments? Chris?
Thanks for letting me talk. Well, the stakes are just too high. A union of police officers is not like a union of carpenters, electricians, or factory workers. These are police officers, and there is no job like it. As everybody knows, police officers are authorized to use deadly force to kill you dead forever. Police officers are authorized to bust your head open with a baton. Police officers are authorized to sting your eyes blind temporarily with pepper spray. Police officers are authorized to administer 50,000 volts of electricity with a taser. Police officers are authorized to punch you in the mouth, knocking out your teeth. Police officers are authorized to search the contents of your pockets. Police officers are authorized to search the contents of your entire house. Police officers are authorized to search the contents of your car. Police officers are authorized to administer fines for the way you drive or what you drive in. Police officers are authorized to strip search you and do a cavity search. If officers accuse you of being a drug dealer, police officers are authorized to take your car, your house, and all your money. And on top of all that, police officers are authorized to persuade a prosecutor, a jury, and a judge to send you to a state prison for years or even decades. Given this enormous power, it's critical that these extraordinary powers are done in public, in the light, and in front of everyone to ensure that these things are done lawfully, with justification, and with good reason. This is the United States of America. We don't have secret police doing secret things, disappearing people to secret torture camps as is done in other countries. There is to be no expectation of privacy when officers do their job doing the public's business. So for years, it has been a travesty that the city of Urbana has allowed the Fraternal Order of Police to control, dictate, and limit the city's Civilian Police Review Board through the contract agreed upon by the city and the FOP. So thoroughly disempowered has the Civilian Police Review Board become, citizens don't bother to use it, and several times the mayor has admitted to the public that the Civilian Police Review Board ordinance needs to be changed. But guess what? Council can't change the ordinance because the FOP contract demands the ordinance comply with the FOP contract. Also, this contract does not explicitly state for what intentional misconduct officers can be terminated. We need to warn officers that there are lines you will not cross and assure citizens Urbana takes intentional misconduct seriously and it will not be tolerated. But none of these needed changes were allowed to be bargained with the police union. The last contract expired in June or July of 2020. Nothing much was done because of the pandemic. And so it fell to the new council sworn in on May 3rd to finalize an agreement with the police. We went into closed session about the contract on May 17th. It is here where I need to apologize to my constituents. I naively assumed that because I was being asked to approve a new contract with police, I would be allowed to give input as to what needed to be changed. For the entire summer, City Council was told nothing. The contract was never discussed. Even after a contract was approved by the negotiators and given to the rank and file members of the union to approve on August 12th, Council was kept ignorant as to what was going on. Suddenly on September 3rd, the City Council was given its first look at the new contract and told to approve it on September 7th. In closed session on September 7th, we were told by the labor attorney that no changes could be made to the contract because that would be an impasse and the entire proceeding would be given to something called an interest arbitrator, something we were hearing for the first time. I'd like to thank Michelle Brooks and Ben Gert for their efforts on the contract. I appreciated their candor. They did improve this contract in several ways, and I want to acknowledge that. As for my council colleagues, I respect however you vote tonight. I know you have the best interests of the city at heart. In my opinion, city council is being asked to pretend that everything is good with this contract so as to avoid trouble. But nothing is going to change. Needed reform can never happen if city councils here and in the state of Illinois and across the nation continue to bend the knee to the almighty FOP. The FOP works for the city, not the other way around. Even though my vote tonight won't mean anything or do anything, I refuse to play pretend. Thanks for letting me speak.
Any other comments? James?
Actually, this is more of a clarification. If council were to be split 3 yeses and 3 nos and a present, my understanding that a tie is a fail and that it would not pass. Is that correct?
Yes.
Okay, I just wanted to clarify that. Thank you.
Does the mayor vote on this to break a tie?
You can. I believe so, Diane.
Dave, can you verify that?
Yeah, that's true. It's one of the provisions for which the mayor can vote is to break a tie.
Grace?
Thank you. I had another question about the CPRB side letter. If I could just have some clarification on how this fits in. I mean, it seems like it's part of the contract, but also not, like part of the bargaining piece, but not the contract. And then at the end where it says that neither party is waiving its position or rights regarding whether the CPRB issues discussed and or negotiated during the negotiations were mandatory subjects of bargaining. And then the next one, that neither party waives any rights under US or Illinois constitutions, which the parties would ordinarily enjoy absent the execution of the side letter. So I'm just confused and kind of the bigger picture too, with the city being in control of the ordinances and how this ordinance is a part of the contract when that would be something that otherwise the city would have complete authority over.
So first, before I address that question, Councilwoman Wilkin, I want to go back to one of your earlier questions, and I apologize for that. The discussion that we had about retroactive complaints that were not signed or were not based on first knowledge, I want to modify the discussion we had in terms of the process on that issue going forward. If the council is in fact interested in making sure that complaints don't need to be signed. We've taken care of that from a contract perspective. While this discussion has been ongoing, I just looked up your city code and muni code online, and that personal knowledge and signature requirement is still in the city ordinances. So that's something that the council would have to address there as well. And to the extent the CPRB has incorporated that into their own rules and regulations, the CPRB should do that there as well to make sure that council's intent in that regard is effectuated. To your question right now, and apologize for the little detour. The language about preserving the parties' rights as to what is and is not a mandatory subject of bargaining. I'm gonna have to dive into the weeds of labor law a little bit here. There's a dichotomy between what's called mandatory subjects of bargaining and permissive subjects of bargaining. Mandatory things we have to talk about. Permissive are things that we don't have to talk about. We can just do as a matter of managerial right, or perhaps we're forbidden from doing because of a union statutory right. So for example, waiver of statutory rights is a permissive subject of bargaining. We can ask to talk about it, but if either side says no, you're not allowed to insist on that change to the point of impasse. In broad categories, managerial rights are fundamental management prerogatives. The size of the organization, the overall budget of the organization, the organizational structure, how you're divided into different departments, how work is allocated between different departments, the standards of service that you want to provide to the public. are generally considered inherent managerial rights. And those are things that you can do unilaterally by yourself without negotiating with the union. On the flip side are mandatory subjects of bargaining, and mandatory subjects of bargaining are things that relate to wages, hours, terms and conditions of employment. Very, very broadly speaking. Wages is obvious, anything to deal with money, vacation benefits, sick leave benefits, health insurance benefits, pretty obvious. Hours, what time do you work? How many days a week do you work? How many hours do you work? That's pretty straightforward. The final bucket, though, of terms and conditions of employment is a pretty broad and amorphous bucket in terms of what exactly is a term and condition of employment. For example, just bringing something into modern dialogue, do you have to get vaccinated in order to work as an employee in the city of Urbana? That vaccination would be considered a quote unquote term and condition of employment. So that would be considered in many cases, I'm not making any admissions for my union colleagues who might be listening to me tonight, but in many cases that would be considered a term and condition of employment. Now we get into emergencies and waivers and stuff like that, but just really, really broadly speaking, that's the case. Well, what happens is those two big buckets of information, inherent managerial prerogative, wages, hours, terms and conditions of employment, they overlap with one another. And when they overlap with one another, our labor board in Illinois applies something called the Central City Balancing Test, which is they weigh the benefits of bargaining over an issue against the burdens on management's inherent managerial authority. That's the standard. In terms of how that balancing test weighs out, there's not really a good way to predict how the labor board might rule on a particular issue. So when the CPRB language was created, whenever it was created, in terms of that balancing test, in order to get the union to buy into the CPRB process, which is not even, it's not terribly common in the state of Illinois. The balancing that was worked out was we said, look, let's just put, and I say we, it wasn't me, I wasn't the one who negotiated that language originally, but the parties said, let's just put our swords away. Let's not fight over what is and is not a mandatory subject of bargaining, because that would be a really expensive, long drawn out battle at the labor board. And I would point out again to the discussion we had earlier on in terms of the law not being neutral, in which way it's slanted. I'm not sure that I like the way that would go, but the parties have said, let's not fight about that. Let's just talk about what the actual process of the CPRB is going to be. So that's a long-winded way of answering your question. It's a complicated legal issue. I hope I've addressed it to the best I can. If there's a follow-up, I'm happy to address it.
I guess the more direct question then is that, is this a required part of the bargaining contract, the side letter?
So, and you had asked it earlier, a different part to the question as well, which is why is it a side letter and why is it not in the contract? And legally, they have the same exact effect, being it a side letter or being it in the contract. It's added to the contract at the end anyways. If the city wanted to get hyper aggressive and say that we don't have to bargain over the CPRB at all, we could take that hyper aggressive position with the union, and it would result in litigation at the labor board as to whether it is mandatory or permissive. The union would take the position, almost certainly not to argue on their behalf, but that it is a term and condition of employment because it relates to who's going to scrutinize their actions. It relates to who's issuing discipline, who's second guessing discipline. There's a contractual grievance arbitration mechanism that the Labor Act says is the sole avenue for resolving labor disputes. If we wanted to send that question to the labor board, it's certainly something that we could look at. But again, keeping in mind the caveat that it's called the labor board, not the management board.
Thank you for the clarification. I think particularly the part about felony conviction is something that's, been an issue, and it seems like this kind of ties all hands, at least until June 30th, 2023. My understanding is that this was a letter from September 2011 and is part of the agreement through June 30th, 2023, and then will be renegotiated in the new contract. And will that, I mean, I guess there's precedent that this is part of the negotiation, so it would maybe be in the same situation with the next contract.
Yeah, yes, with the small caveat that let's say that we're right and it is a permissive subject of bargaining. There's case law that says it doesn't convert into being a mandatory subject of bargaining just because you voluntarily bargained over it in the past. So that's why there is that reservation of rights there. So if it's permissive, it's still going to be permissive next time around. But yes, the next time around, if the council at that time says, look, our number one priority is getting rid of that felony restriction, just by way of example, then that would be the same bargaining process next time around, trying to remove that restriction in the side letter.
Thank you. And then my comment too, I would encourage us to highly consider that, taking CPRB off the negotiating table with the FOP, because it seems like this is the one avenue that the public and the city have for oversight when the police are already involved in their own labor negotiations, their own investigations about discipline, their own disciplinary system, that this is the one avenue that is more controlled and centered around the public for oversight and review body. And I don't think it's right that it's part of the FOP negotiating things on the table when this is, in my opinion, something that needs to be more of an independent review by the public and by the city and its board members.
Anyone else wish to comment? Jaya.
I want to start by thanking, everyone who's been part of this process, and especially my other council members or my fellow council members for all of their feedback and input. This particular contract, there are high stakes. I think, the concerns about the CPRB are very real. I would echo what Mary Alice said of also really valuing some of the changes, specifically removing the requirement that CPRB complaints be signed. I think that's a really important thing that should increase people's access to that process without fear of retaliation. I think that's really important. Changing how long disciplinary records are kept is really important as well. We're talking about going from months to years, if I'm remembering correctly. And I will admit I'm struggling with this. I have struggled with this. I've looked over it quite a bit, and the balancing the desire for more change versus also seeing those pieces that are really meaningful is something that's really complicated. I would also encourage folks to think about the fact that these challenges are related to state law, right? So I can say for myself, I will be reaching out to my state representatives about changing this, and maybe next time around, this won't be the same issue, because those are things that can be changed. The arbitration process could be changed at the state level. Our hands are somewhat tied because we have this looming fear of an outside entity, whether it's related to contract negotiation or if it's related to discipline of officers who may have committed misconduct. And so thinking about how do we change that so that our local municipalities have the authority to do what they think is right should be another part of this conversation as well.
Any other council comments? Okay, well, before we move to the vote, I want to thank everyone on the negotiating teams on both sides for the very, very hard work and really diligence that was put into this, and it was very thoughtful, as well as to all the council members for your comments. This is one of the hardest votes you'll ever make, and it's not the first time, but you're weighing many different factors here, including your fiduciary duty to the city, the overall operation of the city, and continuity here. But again, it's you're also weighing it against expectations and personal convictions and the desire for change. So it's a tough vote, but this is a very good contract in the context and framework in which we have to operate. As Jaya pointed out, and as others have as well, much of this is out of our hands as far as the laws under which we must operate and the framework. The language with CPRB was set into motion 10 years ago, before any of us were, well, I guess I was around, but it's been around for a while. So we are operating to the best of our ability in the context that in the legal framework that we have to operate in. So I appreciate your very thoughtful consideration. And as I said, we'll be at this again before we know it. So there are other opportunities coming up for further incremental or further fundamental change in the way that you would like to see. So with that, will the clerk please call the roll?
Don't you need a motion and a second before we go forward with this?
We had a motion by Mary Alice and a second by Sharice.
Okay. Ms. Wu,
Yes.
Mr. Quisenberry,
Yes.
Ms. Wilkin,
Present.
Mr. Evans,
No.
Ms. Hersey. Ms. Hersey,
Yes.
I believe she,
Ms. Colacetti,
Yes.
Ms. Bishop,
No.
so I have 1, 2, 3, 4 yes, 1 present, 2 no. And the present will be reflected on the winning side, the majority side. Is that correct?
yes.
Okay, that motion passes. Thank you all. All right, we'll move on to council input and communications.
Additionally, I want to note that the comments we're hearing about the FOP contract. I remain committed to a comprehensive review and evaluation of police and public safety in our city. I think that's really important that we continue to work towards that. I agree that there was a lot of frustration at last week's meeting. People commented on how much time council committee members spent in closed session. And part of that was to make sure that we had as much information as possible before we move into this decision. I can say for myself, at the very least, I do read every single document that is given to us. I do have concerns about the inclusion of that language about the CPRB and participants with felony convictions. I also think that the bargaining team that worked on this contract did a remarkable job. So I think that both those things can be true. And I look forward to further discussing it this evening.
Thank you. Just want to also thank the public for your input and say that I hear overall a call for accountability, transparency, and public involvement. And to say that I agree with those things and we'll keep working on trying to do those and have that be reached the best that I can. So thank you for your involvement and continuing to follow along and give your input.
Yeah, I just want to add that when we have closed sessions and there's situations like that, it may not always be apparent, but I would like to thank my fellow council members. I think this council has had some good discussions, and I appreciate the questions my colleagues ask. It's not required that we agree on everything, but it is important that we turn things over in all different directions to understand them. I think as we've been doing this, we've learned some things in the past 4 months that we need to have to be an effective council going forward. And every step of the way where we've had frustration, there has been good discussion about steps that we think we should take to alleviate that in the future, so that as a council that is going to be working together over the next 3.5 years, we're learning how to support each other and how to ask for support from staff and from the mayor to be able to do the best possible job we can. And I think I appreciate that, and I certainly appreciate my colleagues here.
Good evening, everyone. I'd just like to say that we ran on ideas that we would like to see change. We've been in this position for 4 months. I don't know what sort of habits or changes that you hope to make in that short amount of time. Typically isn't possible even to change a habit that quickly in 4 months. So I'm just asking the public for a little grace as we work through discovering what works and doesn't work. We don't know issues and processes until we're going through them. And for instance, changing the code is something that we're working on because we found so many errors or so many issues with the process. And so when we find issues like that, we are going to work to try to move on them as feasible as the council has the ability to. So change doesn't happen overnight. It doesn't happen in 4 months. We have 4 years. So I'm just reminding the public that things like this take time. Thank you.